You're welcome. Yes, once again, a very warm welcome to all of you. Walaikum Assalam. We were deliberating different perspectives regarding the construction of definition, understanding of definition, narratives on definition, dimensions, dilemmas, paradigms, and intersectionalities which have been involved and deliberated under these perspectives. So far, the refugee definition is concerned. In the same vein, we have tremendously witnessed what kind of an extreme internationalization has taken place of refugee definition in the schematization, in the reception of refugee definition in 1951 UN Convention relating to the status of refugees. And we have witnessed, if you recall what I have submitted yesterday, we have witnessed this individualization of the refugee definition or refugees in terms of their protection, in terms of their safety, in terms of shelter, sanctuary, and a complete range of rights which they are generally demand, and that should also be provided to them under the relevant laws of international law, of the regional legislative mechanisms, and national legislations. Now I take you to another important perspective that is equally important, and that has really given us a cue how to further evolve and develop international refugee law. International perspective is primarily and currently gyrates around our international understanding of international human rights law. Because it is the safeguarding of human rights, and that should be regarded as the best way to prevent conditions that force people to become refugees. It is the respect for human rights, my dear friends, and you are already well acquainted with the niceties of human rights. What exactly are the niceties, nuances of human rights which are involved in each and every kind of human movement. Therefore, respect for human rights is the key element in the protection of refugees, not only in the country of asylum, but even in the country of origin, in transition, in destination, and in transmigration and remigration. Whatever may be the nature and situation, we should not forget that the preservation, protection, and promotion of human rights is the key element, which is an inalienable aspect of the human mobility and human existence. Therefore, accelerated and improved observance of human rights standard is often critical for the solution of refugee problems, it has been seen, whereunder refugees are enabled to return to their homes, as has been the case So far, the entire trajectory of the durable solutions, if we try to understand, then one of the most important and very first solution that is offered under this trajectory, that is known as voluntary repatriation. It is essential, my dear friends, that the international community or community of nation states affirm and defend vigorously and very vehemently the right of people or right of the people to remain peacefully in their homes and homelands, because when people are forced to leave their homes, a whole range of rights is threatened, including the most essential and very substantive rights, which are popularly known as the right to life and security of the person. In this conspectus, my dear friends, organized international action on behalf of refugees began in the year when the League of Nations was faced with the problem created by about the million refugees who had left Russia in consequence of Bolshevik Revolution in 1917. International Red Cross Committee appealed to the Council of League of Nations in the month of February, if I am not wrong, in 1921, to take action on behalf of the Russian refugees scattered throughout Europe without legal protection or representation. If you compare the same kind of a situation, though it was the result of a revolution, my dear friends, but if you take this particular cue, you will not surprise, because still the similar circumstances are present at international level. If I take you from Russian scenario of 1921, when the refugees were left high and dry without any kind of a legal protection or legal representation in any of the bodies entrusted with the protection of refugees. Right now, if I take you as a case study, to the United States of America. In United States of America, there are as many as 3.3 million unauthorized immigrants. After the inauguration of the Joe Biden presidency in United States of America, there is a ray of hope. There is some kind of a solution which is being under contemplation, which is being contemplated. How to grant a citizenship to these 3.3 unauthorized or 3.3 million unauthorized immigrants currently living in United States of America. There is one institute in United States of America who has released a report yesterday. And that too in the mid of night. This is the institute which is known as Migration Policy Institute. As per the report of this, Policy Institute, my dear friends, out of these 3.3 unauthorized, they are not using the word illegal. They are using the word unauthorized. So unauthorized immigrants. And this institute, they have released a policy statement as well as the estimates. And they categorized them into dreamers and other important or farm workers and holders of the temporary protected status, TPS, that is popularly known as. So these people are going to sponsor their spouses in their country of origins because of the some important messages as well as some important situations which have been created for their livelihood, for their engagements, for their employment. And ultimately, a new kind of a legislation has been moved before the US Congress, which is popularly known as US Citizenship Act of 2021. And that has been introduced by the lead sponsor, Senator Robert Menendez and the Representative Linda Sanchez. This particular piece of legislation is bound to create an 8-year path to citizenship for these 3.3 million unauthorized immigrants. Not all of them are going to be accommodated right now, but at least, my dear friends, majority of the people are going to be accommodated. So that really establishes the international action. Because Joe Biden's administration's policies of accommodating unauthorized immigrants and creating pathways for their citizenship, whatever may be the track, time frame that is required. In this case, it is going to be the 8 years. And those who have completed these 8 years, they are going to be automatically going to be conferred upon with the US citizenship. Joe Biden's administration policies is a continuation of the Obama administration policies, and there has been some kind of in terms of the immigration accommodation, the Trump administration should be considered as some kind of a political interregnum, a jingoistic interregnum, or revanchist interregnum. That is my understanding. Otherwise, Obama administration's policies, whatever the policies in the name of DACA, you might have heard this abbreviation. Same kind of a policies, again, relaunched, reinitiated, and majority of the unauthorized immigrants are likely to be accommodated. It really establishes an international perspective, my dear friends, because it is the efficacy of this kind of a system that really comes handy for the accommodation of refugees, asylum seekers, immigrants, and other important stakeholders. In majority of the situations, it is generally alleged that the United States of America is not at all discharging its international human rights obligations. But if you study and have a deep study, a very intensive and extensive study, what has been the accountability as well as the responsibility sharing premises on the part of the United States of America, then we will come to know that during Obama administration as well as the present one and the previous what we call democratic political setups and governance structures in United States of America have been amenable to the refugee accommodation. Though conditions have been stipulated, and these conditions in certain situations have been very stringent, but we cannot accuse the United States of America. I am simply talking in the context of the refugee resettlement, reintegration, and refugee accommodation. Because we have to be impartial, because I have also shared during my previous submissions what has been the response of the United States of America, particularly in 2017, 2016, and 18. To your seniors, an entire estimate I have shared with them, particularly during the Obama administration, what has been the program and policies. So international perspective demands what has been reflected, my dear friends, in the global compacts of 2018 on refugees and migrants. Same has been the case with other important, nation states, with minor what we call, exceptions. Suppose we can take the example of Australia. Australia has been very sincere in accommodating refugees, but there has been an unwritten policy of racism. They preferred only the white refugees or the brown refugees. They haven't, preferred black refugees or the black people. Therefore, at this stage, my dear friends, it must aptly be, observed that the movement of refugee law away from principles of humanitarianism intensified in the current, scenario. And that is why up to New York Declaration of the 2016 on refugees and migrants, we have witnessed a new kind of a canvas, a political canvas, how to accommodate refugees. And at the same time, my dear friends, it is no longer suffice to be a member of a group of displaced people or the stateless what we call persons. Rather, I am of the view particularized analysis of each claimant's or each refugee's motives for flight was requisite to recognition as a refugee. Therefore, individualization of refugees is not going to serve the purpose. Rather, the holistic view should be taken. Holistic view should be, applied when there is a question of determination and how to extend protection and humanitarian aid and assistance to the refugees along with other important, rights. So specific programs have been initiated. Similarly, in United Kingdom, it is the, immigration legislation that is being fine-tuned along with on the lines of what we call the Human Rights Act of 1998 in United Kingdom. But at this stage, the observations of the Hannah Arendt, a French theorist, a political thinker, a governance evaluator, and many other important adjectives should be attributed to her. She was right. And she observed, my dear friends, that the minority treaties made explicit what was hitherto implicit in the workings of the nation states. And only nationals could be citizens, only people of the same national origin could enjoy the full protection of legal institutions. That persons of the different nationalities needed some law of exception until or unless they were completely assimilated and divided from their origin. It means when we go through these kind of observations, it means even the Hannah Arendt, who has once rightly observed that refugees lack a right, and that is only one right that is not available to them. And what was that right? The right was in his very famous and unprecedented treatise, which is popularly known as the totalitarianism. In that particular treatise, she writes, refugees has a right to have rights. So a refugee has a right to have rights. That is the most important observation made by Hannah Arendt. Therefore, if you take an example of the minority treaties, my dear friends, these minorities treaties were created by the League of Nations in order to provide protection for those people who were a minority in a state and who had no state. The outlined, if you take into account, these minority treaties have also outlined and enumerated the duties that the minorities and their new states, as well as the details for how the states could go about assimilating the minorities into dominant culture. And that is why, if you take into account the recent migration, my dear friends, you will appreciate, because I am really in favor of preserving one's identity, cultural identity, linguistic identity, religious identity, political identity. And right now, what we have been witnessing within our national jurisdictions as well as international jurisdictions, that the people have been indulging in identity politics. But it is equally important, my dear friends, and this is in my personal capacity, I am airing my views, that it is basically, in my scheme of understanding, it is the human existence, it is the personhood, it is the humanity that under all circumstances must be saved. And so far the identities are concerned, we can discuss them at a subsequent stage. What is important and what is at stake is, it is the human existence, it is the humanity, it is the sense of safety which must prevail in the minds of people who happen to be in exodus or in influx. Therefore, we have been witnessing of late that in France, in Belgium, even in Germany, they have been receiving and other European nation states under a quota system as well as under the EU regulations. And the European Council directives are also there. Under this EU acquis, the refugees are being received. And in majority of the situations, they have been accommodated. But there are some fringe groups, there are some political implications. Because of those political implications, even some people have been facing hostile environments at the borders. But these nation states have started separate programs for their accommodation. And they have been following a policy of orientation programs for the new arrivals of refugees. Whether the individuals are arriving or the group of refugees are arriving, they have to attend some orientation programs, because in these orientation programs in Belgium, in France, in Germany, they are being taught, I mean the refugees are being taught about the cultural shocks, cultural deviations, cultural accommodations, linguistic requirements. Language interpreters have been appointed to make them understand the new languages like German, French, and other European nations' languages. The intention has always been that under these circumstances, they should be accommodated. In the new environments, they should not feel, and there should not be any kind of a sense of exclusion and sense of alienation. And therefore, they should also be the part of the dominant culture. Dominant culture does not mean that they should be subjugated. It means that the culture of the majority community that is in practice, they should also feel the part of that very culture, because under a policy of assimilation, under a policy of integration, they want to, I mean the national governments of these European nation states are willing to make a presentation, a unified presentation of their population. So it is good, my dear friends, At least they should what you call learn, because if you see South Asia, you will also appreciate my line of argument, though I am ready to accept all your disagreements, because these disagreements are equally important. If somebody is visiting Khyber Pakhtunkhwa in Pakistan, or in Dhaka, or in Kerala in India, or in Karnataka again in India, or Baluchistan in Pakistan, people are of different faiths. Peoples are living there with different identities. But a Muslim from Kerala does not speak Urdu or Hindi. He is uncomfortable, despite the fact he is a Muslim, but he is uncomfortable with a Muslim from North India in terms of culture, in terms of eating habits, in terms of cuisine, in terms of many other important features of human existence. But he comes, if he visits a Hindu Keralite from Kerala in New Delhi, he would be very comfortable. So this is the situation, and that is why I advocate in my personal capacity that it is the life of a refugee that happens to be at stake, and that should be what we call saved first. A shelter should be extended. A sense of security and safety must be extended to them. So it is very, very important, my dear friends, and that is why.
Sir, I have a question, sir.
Yeah, please. Most welcome.
Sorry for interrupting you.
No. Please don't say sorry.
Sir, okay, thank you, sir. As you are talking about, sir, accommodation of refugee world over, all over the world, during the Syrian crisis, safe zone was created by Turkey and Russian agreement between the Syria and Turkey border to shelter the Syrian refugees. As Turkey is hosting millions of refugees, millions of Syrian refugees. So, sir, my question is, what is the status of safe zone under international law, or particularly under international refugee law? I think this safe zone has been created sometimes, like in North Korean border. I think while the Korean War was taking place, or somewhere else. I'm not knowing much about this, sir. Can you please respond to this?
Yeah, thank you very much, Asif Saab, for your very fruitful intervention. And again, though since first semester I have been submitting, and once again I submit, this is your prerogative to disturb me at any moment. And it is not at all disturbance. It is basically a process of enhancing and attributing some vibrancy to the ongoing deliberations in the class. So please ask questions and enrich this entire interaction. So thank you very much for your intervention. Your question regarding the status of these kinds of specialized zones for the hosting of refugees, as you have mentioned, that has been created by Turkey under EU-Turkey deal. My question or my submission on this particular point would be, my dear friends, you have already witnessed that there are certain important earlier practices have always been there regarding these kinds of construction of these kinds of zones. Let me put this mic, because there is some noise outside. My submission, if you recall, in one of my earlier submissions, I have submitted that if you take into account the program and policies which have been initiated by the government of Australia, particularly for the boat people, then the boat people were not welcomed. They were hailing from Rwanda, from Nigeria, from other nation states of Africa continent, and therefore it has been thought under an unwritten policy, which is popularly known as, I have already deliberated this particular, policy in the online, classes, and that is all white Australia policy. Under that very policy, government of Australia entered into an agreement with the government of Papua New Guinea, and they have erected, my dear friends, some enclosures, some detention centers. Though subsequently the Supreme Court of PNG, Papua New Guinea, have set aside this kind of a measure on the part of government of PNG, and between, rather I should say, between government of PNG and Australia, and it has been dismantled at a later stage. Similarly, so far international law is concerned on such kind of centers, then it is a violation. If these kinds of enclosures have been created and erected, then it is basically a violation of international law. We can also I'm sorry, we can also equate this entire understanding what has been adumbrated by the International Court of Justice in the construction of wall case. So these kind of arrangements, it is basically a negation. But we have to see what kind of a construction of camps, or construction of walls, or construction of camps have been there. To what extent the rights have been made available to these kinds of refugees, and whether it is going to be some kind of a transit accommodation for the refugees, whether they have been asked that prior to the determination of their refugee status, they have to spend some limited time in these kinds of camps. The camps, what kind of a facilities are being enjoyed in these camps? Because what we have been witnessing in rest of the European nation states, and recently in the Cox's Bazar area of Bangladesh, where the refugee camps were set on fire. And we have also witnessed that many refugee camps have also been set on fire in the European nation states. So therefore, if you take into account the legality, validity, and constitutionality of these kinds of arrangements, then these arrangements are basically humanitarian in character. But at the same time, we have to take into account what kind of a treatment is being meted out to refugees, whether that treatment is there as per Article 33, 33 subclause 1, 28, and the 31 of 1951 convention. At the same time, we have to take into account the torture convention and its Article 3. Then again, we have to resort to Article 12 of the ICCPR. Then we have to undertake Article 13 and Article 14 of the Universal Declaration of Human Rights, whether these arrangements are conforming with these legal requirements which have been contemplated. And by virtue of being the members of the community of nation states, EU as well as the government of Turkey is accountable under even customary international law as well as under the constitution of Turkey, because adequate constitutional guarantees have also been there in the constitution of Republic of Turkey. So my submission would be that there is no harm, my dear friends, because as long as the protected status of refugees, that is TPS, or the protected what you call refugee status, is being what you call upheld in these camps, then it is good. As long as these kinds of arrangements are temporary in character before the full-fledged accommodation or full-fledged resettlement of refugees, whether in the country of origin or in the third country, then it is good, because it is the human life that should be what you call saved. It is the human existence that happens to be at stake, and that should be equally protected. So this is what I feel about these kinds of arrangements. But people are making certain wild allegations as well, because in these camps, as we have been witnessing in the Cox's Bazar area, and my friends from Bangladesh can correct me if I am making some kind of a wrong statement, that it has become a den of criminals. They have been indulging in human trafficking, all kinds of crimes are being committed in these, refugee camps, particularly in the Cox's Bazar area, despite the fact, and it is refugee versus, refugee kind of, crimes, and they are also indulging and committing crimes against the state of, Bangladesh. So we should be very careful whenever we are, organizing these kinds of, facilitating, I mean, installations for refugees or any kind of a, detention centers, not exactly the detention centers, rather the transit, centers. That would be the more appropriate, terminology. And the government of Turkey has also established not the detention center, rather the transit accommodation, the transit, what we call, camps. Every refugee camp is a transit camp. That is my, understanding. But ultimately, they have to be reintegrated. They have to be resettled. They have to be, assimilated in the dominant culture, the majoritarian, what we call, culture in the country of what we call, reception, or the country of, destination, or in transition if they are, heading towards a particular, country for permanent, settlement. So these questions should be taken at a later stage. But what is important is that it is the personhood of refugees. It is the, dignity of what we call of, refugees. It is the livelihood of the refugees. It is the health of, refugees. It is the mental, what we call, framework of, refugees. It is the question of the mental health of, refugees, whether these, different rights are going to be protected or have been, protected under what we call, under under these kinds of, I mean, arrangements. So it is all, hunky dory, but as long as that remains a temporary arrangement. Any other observations on your part, any intervention, or any other, supplementaries? Asif sir.
No, no, sir. Thank you, sir. Thank you for your kind observation on this. Thank you, sir.
So now there is another I'm sorry. Another important, observation we should also, evaluate. And that evaluation, basically, I attribute this kind of a, evaluation as the, post 1951 utilitarianism. Because in this, idea of utilitarianism, I'm not here to deliberate, and it is not going to be a jurisprudence class. And I'm not here to deliberate what Jeremy Bentham has opined. This is something you have already studied at your graduation level as well as in your very first semester. I'm basically trying to apprise you that it is not only the 1951 UN Convention relating to the status of refugees with this additional protocol of 1967. And these two instruments are considered to be the bedrock of international refugee law. And we must try to understand the utility and the utilitarianism of these two important instruments. But at the same time, we should not forget that there is another important instrument, my dear friends. If you recall, I have also mentioned very briefly when we were, discussing the sources of international refugee law. But there are, certain specific articles of the statute of the UNHCR and the mandate under this particular statute that has been contemplated by the collective wisdom of the entire membership of the United Nations General Assembly. The primary standard, my dear friends, the primary standard of refugee status today is that it derived from 1951 convention relating to the status of refugees. There is no denying of this particular fact. But 1951 convention, my dear friend, was a sequel to some of the major attempts by the United Nations to define a refugee, which were made in 1950 drafting the statute of the Office of the United Nations High Commissioner for Refugees. And in 1951, when the United Nations Conference of Plenipotentiaries adopted this particular, convention of 1951, that is we have been, talking of. In both the cases, a recent attempt was made to revise and consolidate previous instruments relating to the status of refugees. If it is a sequel, and it has been a sequel so far, 1951 convention relating to the status of refugees is concerned. To this end, my dear friends, both definitions, the definition that has been provided under 1951 convention and the definition that has been provided of a refugee under the statute of UNHCR of 1950. These two definitions begin by recognizing as refugees persons so recognized by various pre-war arrangements and pre-war conventions. So far the UNHCR statute is concerned, or as per the UNHCR statute, the work of the United Nations High Commissioner for Refugees is humanitarian and social and entirely non-political or of non-political character. If you take into account Article 1 of the statute of the UNHCR, then Article 1 provides, my dear friends, that the United Nations High Commissioner for Refugees, acting under the authority of the General Assembly, shall assume the functions of providing international protection under the auspices of the United Nations Organization to refugees who fall within the scope of the present statute and of seeking permanent solutions for the problem of refugees by assisting governments and subject to the approval of the governments concerned, private organizations to facilitate the voluntary repatriation of such refugees or their assimilation with the new national communities. So if the governments or European national governments are organizing, my dear friends, some orientation programs for accommodating the new arrivals of refugees as per their traditional cultural models, then they are not committing any kind of a human rights violations. Rather, they are going to further preserve the rights of refugees or the human rights of refugees. That is my understanding. Because in the name of identity politics, we cannot indulge and we should not allow ourselves to be a part of any kind of a political chicanery. Because such kind of allegations have already been there. And it has been aired in many meetings at international level. Many note verbal has also been issued by the government of Syria that the Turkey is creating refugee-like situations, and they are siding in the ongoing civil war or ongoing conflict in Syria. Because the government of Turkey is also having its stakes in this kind of a conflict, unfortunately. And therefore, if the national governments are taking some kind of measures, if you take into account the scenario refugee canvas of South Asia, then it is going to be the legitimate concerns of the government or the modern governments of South Asia, I'm talking of all the national governments of South Asia, if they are, undertaking some important measures, and these measures have been accommodating, refugees, but before accommodating them, there's some, orientation programs, some re-education programs, some, cultural training programs likely to be organized. I'm not talking of what you call of, conversions or religious, what you call, practices. No, that is not my, concern, and that should not be, because right to religion is also available to refugees. But at least some minimum, what you call, thresholds of accommodations must be fulfilled. And therefore, if you take into account this particular article, Article 1 of the Statute of the UNSCR, then definitely the actions of the European nations and their, governments, what they have been, doing for accommodating the new classes of, refugees, it is equally important, and they are doing a great job. That is my, understanding. But if you take into account, my, line of argument is further, approbated, and that stands what you call, vindicated. If you take into account Article 6, subclause A of the Statute of the UNSCR, this particular article takes into account any person when we are, deliberating the competence of the UNSCR, that is the United Nations High Commissioner for Refugees, and its, competence. This competence extends to any person who has been considered a refugee. Try to understand. It is having an encapsulation of protection which is retrospective. Retrospectively, it is, taking into consideration the plight of what you call of, refugees, what has been the plight of their, flight. It is being, encapsulated in this particular, article, and that is Article 6, subclause A of the Statute of 1950. And it says, my dear friends, what kind of a, as I have already submitted, that the 1951 Convention is a sequel. And sequel to what? There are other important, arrangements, and these arrangements, particularly the arrangements of May 12, 1926, June 30, 1928, and again October 28, 1933, then again February 10, 1938, and the additional protocol of 14th of September 1939, or the Constitution of International Refugee Organization. These were the, conventions, the dates which I have, mentioned. Under these, dates, these conventions have been, adopted under the auspices of the League of Nations, charter for different what we call classes of refugees in Europe. Therefore, when the statute uses an expression which is known as any person within inverted commas, any person, then it is very, very important, and it has also been extended in the 1951 Convention from the Statute of 1950 of UNHCR. And some important elements have also been, adumbrated as well. It is further, axiomatic from clause B of the same article, and that is Article 6, subclause B of the Statute of the UNHCR. Any other person, first they have, in the subclause A, they are using, the statute has used the word any person. And now it is, further qualified it, any other person. So you can very well understand what kind of a, broad reason has been undertaken by the framers of these kind of, arrangements. So any other person who is outside the country of, nationality, or if has no nationality, then the country of his former habitual residence, because he has or had well-founded fear of persecution by reason of his race, religion, nationality, political opinion, or membership of a particular, social group, or because of such fear, he is not able to return to avail and to what he call get back to his country of nationality or habitual residence. Therefore, my dear friends, if you take into account cumulatively that
Sir,
it is the comprehensive character. Yeah, please. Yeah.
so what difference does any other person makes instead of any person? Like you mentioned it earlier.
Yeah, please. Yeah, thank you, ma'am. Uh, it's a very important, clarification which you are, seeking. Any other person means, ma'am, some amount of liberal interpretation has also been contemplated by the framers of the statute, particularly of this, subclause B. Because here, despite the fact we are having some other classes of, of denationalized people, de-citizenized people, stateless people, displaced people who are lacking national protection, who does not enjoy the protection of their nationality, and they do not belong to any nation states, despite the fact there is a definition under 1954 convention, UN Convention on Statelessness, where Article 1st stipulates that a stateless person shall be a person who does not enjoy the protection of any country. But for the determination purposes, it has been what we call, ordained. It is one of the most important injunction of international, human rights law, that a person who happens to be in a state of statelessness would be determined, and his nationality for the purposes of what we call of his, settlement shall be construed, and he should be considered as a national of that very country in which he or she has been living for a while. So it is basically an extension of the refugee. When we are using this kind of expression, any person is limited to refugees, asylum seekers, migrants, any other what we call person. It means that there is a hybridization. There is a liberalization of the interpretation. A very liberal interpretation should be undertaken, and other important classes should also be taken into consideration, because it is the protection of the government of the country of his or her nationality. It is basically the question of no nationality. If somebody, because no individual is allowed to live or expected to live in a vacuum, so therefore, it becomes very, very important to extend some kind of, protection to that very individual group of individuals, a group of what you call, or a community or group, or other what you call, notions. Suppose we are, talking and grappling a new group of, refugees, that is the LGBTQI refugees. They are also, facing a lot of what you call, problems and demanding. And there are, arguments, minorities in a particular what we call, nation state, who are, subjected to some kind of a discrimination. To what extent discrimination attains the crisis proportions of a or persecution. So we have to take into account all these, emerging what we call, challenges under international refugee law. That is why any other person under sub what we call, clause B of Article 6 of the Statutes of 1950 of UNHCR has been what we call, arranged or rather contemplated. This description, ma'am, I'm still addressing Miss Anupaji along with the rest of you. If you take into account what I have, submitted on any other, person, then if you take into account this observation, it is having a universal application, neither containing temporal or geographical limitations, because UNHCR status contains an apparent contradiction on one hand, but at the same time it affirms that the work of the office under the statute of the UNHCR shall relate as a rule no group, no categories Whether, and that includes in the contemporary circumstances, here lies one of the most important bone of contention. And bone of contention is what would be the fate of the LGBTQI rights refugees, or the women refugees, child refugees, differently abled refugees, or any other class which cannot be contemplated by the human mind in the present, circumstance. I mean, current, scenario or the present, circumstances. But there is a likelihood that posterity may confront some additional categorizations of, refugees. So therefore, at this stage, the word any other person has been what you call resorted, because UNHCR statute encapsulates all kinds of contradictions in terms of categorizations, in terms of compartmentalizations, in terms of demarcation of refugees, and whatever may be the distinctions in different classes. So each one of us as a category has been encapsulated. On the other hand, the statute of the UNHCR also proposes a definition of the refugees which is essentially individualistic and requiring a case-by-case examination of subjective and objective elements. And therefore, stateless persons and other what we call categories, which I generally address as RAMS, R-A-M-S. And I try to address it as RAMS. R stands for refugees, A stands for asylum seekers, M stands for migrants, and S stands for stateless person. Long back, I have used this abbreviation in one of my blogs published by University of London on its website. So, and that really, it was basically this particular article 6 as well as article 1 of the statute of the UNHCR that primarily impelled me to have this kind of abbreviation, and very comprehensively. That is why the element of complementarity came into existence. Element of supplementarity, in addition to the trajectory of durable solution, this particular idea came into existence, and this is how we should try to protect refugees. That has been the entire what we call journey of the refugee protection, and that is why, and it is further what we call crystallized by the New York Declaration of the 2016 under these two global protocols. But these protocols should not have been adopted by the international community as what we call compact. I'm sorry, protocol. I'm sorry, as compacts. Rather, these global compacts should have been adopted as additional protocols after the additional protocol of 1967. So that is my line of argument, and this is something I have been repeatedly submitting in this particular class. Yes, ma'am. Your further observations.
Thank you, sir. I got it.
Yeah, thank you, ma'am. So there is always a reason, and as a lawyer, it is our fundamental domain. It should be our fundamental responsibility, and this is my recommendation, that in the world of law, every word has got some kind of meaning in the formal sense. I'm not not at all talking or discussing informal scenarios. But when we are indulging in some kind of a legal exchange of words, then definitely some of the words attains a very, very important solution. Because informality of law my dear friends, also formalizes and give rise to the emergence of the new vertical avenues for legal understanding. If you recall, I have already submitted in the very first semester of the comparative constitutional law classes that if you want to be, and this is not something which I am opining, it has already been opined by Justice Matterfakan of the US's Federal Supreme Court. To be a good lawyer, there is a fundamental requirement that we are, as a student of international law, as a student of law, supposed to know each and everything under the sun, whether it is the informality of law or the formality of law. Because when the informality of law and informality of law are cross-fertilized, then it creates new avenues for legal understanding. And that is why an interdisciplinary approach is the primacy of our understanding or of our legal understanding. So this is what I feel about international refugee law, because it gives rise to the idea of complementarity, common pathways, supplementary protections, subsidiary protections, temporary protection, surrogate protection, individual protection, voluntary protection, formalized protection, group protection, collectivized protection, individual protection. So these are the different facets of protection, because in the field of international refugee law, what we have been talking of ever since we have started our formal engagements in this particular class, what we have been talking, it is the idea of protection and how we are going to protect all these kinds of because this is again a very, very important idea that really, and the idea comes out of agitation and intellectual agitation in my mind, and that has been pandered to by Ms. Anupaji, that how to strengthen accountability of UNHCR. Because we have to undertake further course of action. Because in the field of international human rights law, international criminal law, international humanitarian law, including international refugee law, there are common pathways, there are complementarities, there are compatibilities. So in such a scenario, accountability plays a very, very important role. And accountability under all circumstances should be taken as a fundamental principle, even for the United Nations High Commissioner for Refugees. Because if you take into account the entire mandate of the office of the United Nations High Commissioner for Refugees, the mandate is to lead and coordinate international action to protect, assist, and find plausible, pragmatic solutions for refugees and other populations of concern. This word becomes very, very important. People of concern. Because tomorrow or right now, there should be another question from your side. And let me ask this particular question to myself on behalf of you. What is the fate? Is there anything in the statute of the UNHCR, United Nations High Commissioner for Refugees, for internally displaced persons, for climate refugees, for environmental refugees? Because there is a, juridical, philosophical, and epistemological distinctions and differences among the scholars. Some scholars address them environmental refugees, and some have been addressing them as climate refugees. But on the ground, the situations are same. So far, their displacement, relocation, migration are concerned. If under international refugee law, there is a concept of durable solutions containing as many as 3 important, well-acknowledged ways for the address and for the accommodation of refugees on different what you call planes. Then in the field of what you call of climate change, in the field of what you call United Nations, Framework Convention on Climate Change of 1992 also contemplates a trajectory of what we call of, that is containing of a, trinity: adaptation, mitigation, and resilience. So we have to create some kind of a, cross fertilizations when there is a question of, climate refugees. That I would be subsequently, attending, because we are going to attend even the climate refugees as a separate what we call, engagement. But let me take myself back to the question, initial question that I have, started to ask them. That is the people of concern. And I raised a question about internally displaced persons. So how internally displaced persons, and what exactly is the mandate which is available to the United Nations High Commissioner for Refugees to address the problems of the internally displaced persons? Because we do not have any resolution, even of United Nations General Assembly on internally displaced persons. But we also got an understanding on internally displaced persons of the United Nations organizations. I'm sorry I was using the word resolution. I wanted to use the word, convention. So we do not have any kind of a UN convention on internally displaced persons, but we are having some important understandings. Understanding in the forms of guidelines. We are having United Nations guidelines on internal displacement of 1998. But at a regional level, we are also having a convention. AU Convention, African Union Convention of 2009, and which is popularly known as the Kampala Convention on internal displacement. And these arrangements, my dear friends, as we have been, deliberating, we should consider these, arrangements as an element of complementarity. Because in the field of international human rights law or international refugee law, nothing should be studied in isolation. Nothing should be contended in exclusion. If the problems of refugees, stateless people, asylum seekers, and other sections of the population, or the populations and people in migration, or in relocation, or in transition, are not what we call, solvable under these two important instruments of a binding character, that is 1951 Convention relating to the status of refugees, or the Statute of the UNHCR, or Additional Protocol of 1967, then we have to look beyond these two or three instruments. Then if we all look beyond, we find a vast what you call pool of international human rights law instruments. So we should try. And these international human rights law instruments function as some kind of a, supplementary or complementarity in solving refugee crisis. And that is why that strengthens the accountability element of entire functioning of the UNHCR. We have to bear in mind what the various, multiple, dimensions. Accountability is defined by UNHCR as a commitment to deliver pragmatic results for population of concern within a framework of respect to transparency. You see the framework. What kind of a framework has been, contemplated for the people of what you call of, concern. It is a framework that, subsumes, that really what you call subscribes to the idea of human dignity, preservation of, humanity, accountability, respect, transparency, common feasibility, trust, morality, or to a great extent, I should call delegated authority. And everything should be consistent with the availability of logistical support and resources. That is the, a moral conviction, because United Nations High Commissioner for Refugees on many occasions branded internally displaced persons as people of concern. It does not directly intervene. UNHCR has not been empowered to directly write to the national governments about the plight of internally displaced persons, but they have been what you call, categorized as people of concern. And that is why the guidelines in 1998 came into existence, which have become, to a very great extent, if you take into account these guidelines, then these guidelines are echoing what has been promised under Universal Declaration of Human Rights, how the judicial system of South Asian regions, how all the judiciaries, highest judiciaries in South Asian jurisdictions, how they opined and observed on different stages in the evolution and formalization so far the availability and protection of human rights and enjoyment of human rights and accessibility to human rights is concerned in these jurisdictions. So that has been akin to that. Therefore, if you take into account this framework narrative, then it becomes very, very important. It is basically a question of trust. It is a question of moral conviction. It is a question of human rights obligation. It is a question of, national commitment, that the people who happen to be on the move, this is how they should be protected on the part of international organizations as well as the national governments. And in this case, it is the international organization, and that is UNHCR as a subsidiary organization accountable to the United Nations General Assembly as well as the Socio-Economic Council of the United Nations organization. This is how this institution should discharge its functions with regard to the people of concern. Because UNHCR's aim is to build a modern system, my dear friends, a modern system of accountability. And when we are, talking within the national, jurisdictions of idea of good governance, then it is equally important for the national governments to discharge their constitutional duties within this particular, framework of accountability. And this is how we should determine the contours of, accountability, and that is sufficiently robust and comprehensive to respond to the different, accountability requirements expected of today's international multilateral organizations, bilateral organizations, regional organizations, and many other important subsidiary organizations. So this is how we should, function as an organization, as a human rights organizations, as a national government, or as some kind of a local body. But we have to be very, very careful when there is a question of refugees, because they are the most vulnerable, marginalized, and defenseless, people. So, because 1951 Convention and the purpose of this, convention has always been very, very sacrosanct. If you take into account entire understanding of 1951 Convention, then 1951 Convention came out with certain important categorizations of refugees. Even the statute of the UNHCR of 1950, they are also This statute is also talking of some kind of categorizations, as I have already submitted. But I am not indulging, and I am not at all in favor of these categorizations. I am basically, in my personal what we call capacity, and as a student of international refugee law, I am more concerned about the receiving end. How the benefits of these conventions have been trickling down to refugees and how they have been protected. That is the most important argument. Because the groupization, categorizations, collectivization, it is all nothing but an exercise. Although I am not denying the fact, I am not at all underestimating this kind of categorizations, but that is a time-consuming mechanism. Because I feel that definitions are important, but at all time we should not talk of definition. And that is why the beauty of 1951 Convention definition is that at least, because if you categorize this entire definition, then I categorize it into two parts. One part is taking into consideration the well-founded fear of being persecuted. So well-founded fear is one part, and being persecuted is the second important part. To forget about the rest of the items which have been adumbrated in the definition. In the very first part, sometimes we are accosted with there is a determination of the province on subjective lines as well as on objective lines. But we find a lot of what we call level playing field, lot of leverage in the second important part, and that is being persecuted. Because the province of persecution has not been defined. Because we have to find out the basis of protection, basis of refugee protection. In broad terms, my dear friends, Article 1 of 1951 Convention adumbrates the basis on which protection to refugees is granted, or denied, or discontinued, or seized. Therefore, a well-founded fear of persecution based on reasons is specified in the definition under Article 1. Particularly, one of the most important fragment which we have already deliberated, and that is outside the country of origin, nationality or habitual residence. It is also evidenced, my dear friends, by unwillingness to return to such a country. These all kinds of conditions which we have deliberated are significant elements in the definition of a refugee. But the word persecution has not been defined. It is really a sense of satisfaction on the part of what we call of the framers of this definition in 1951. Because had they defined, it would have been very difficult to extend the protection contemplated under this definition to all the categories of refugees, including the categories which I have mentioned, or the categories which have not been contemplated but contemplated under the statute of the UNHCR. Therefore, element of well-founded fear of persecution is clearly the most important factor concerning the determination of refugee status. Well-founded fear. There are other elements as well, like outside the country of origin, nationality, habitual residence, unwillingness. These are basically the questions of fact, because the factual situation has to be taken into consideration and they constitute evidence of the claimant's fear of persecution in the country of origin, on the ground of nationality, or on the ground of habitual residence, as well as of the fact that they lost the protection, national protection of their government. By contrast, the criteria of a well-founded fear of persecution is a legal standard whose applications is considered by the existence of the objective facts. If you take into account one adjective that has been used as a prefix and which is known as well-founded, that denoted a fear based on reasonable grounds of persecution. So there is a test of reasonability, reasonable grounds of what we call of persecution, because well-founded fear, or the word well-founded within inverted commas, suggests that it is not the frame of mind, my dear friends. It is not the frame of mind of the person concerned or the refugee concerned, which is decisive for her or his claim to refugee status, but that this claim should be measured with a more objective yardstick parameters. This kind of a phrase, the phrase well-founded fear or well-founded, means there must be sufficient impeachable, the ground should be or the facts should be there, whereunder a claimant is able to justify the conclusion that the applicants for refugee status would face a serious possibility of being subjected to persecution upon return to his country or her country of origin. That is the basic understanding. Whereas, in other words, let me put it like this: well-founded fear means, my dear friends, that an applicant must give a plausible account of why she or he fears persecution. Number one. Refugee applicant must show good reason to fear persecution by adducing evidence of an objective risk. And such kind of contentions must be consistent with certain decisions made by the superior courts of records in leading common law jurisdictions or the civil law jurisdictions. Because subsequently I would also be coming to the case law. There have been instances in United States of America, in Canada, in France, in UK, Germany, Italy, Australia, where such kind of contentions have been demanded by the judicial establishment from the applicants for the refugee status. After their unsuccessful attempts of getting refugee status at the level of refugee status determination authorities or at the level of RSD officials. RSD, the full form of RSD is the refugee status determination. So therefore it becomes very, very important that the well-founded fear must have a reasonable, what we call, account, a plausible account, a pragmatic, what we call, presentation that takes into account the thresholds, the degree of, persecution or likely to be what we call, there. Therefore, the consensus of judicial opinion has added content, my dear friends, to the meaning of the phrase well-founded fear. Well-founded fear of persecution in the context of the standards which have been contemplated in 1951 UN Convention relating to the status of refugees. This reminds me of one of the most important, judgment of 1987 that was delivered by the United States of America's, Supreme Court. And in this particular, and that is, INS versus, Cardoza Fonseca, which I have also on earlier occasions in the same class, I have, cited this particular, decision. Here in this particular, decision, the Honorable Supreme Court of the United States of America has identified and laid down a very, very fantastic test. And that is a test of reasonable possibility of persecution within inverted commas. And that test has been, taken as a basis for determining the meaning of the well-founded fear of being persecuted or well-founded fear of persecution, whatever may be the, nomenclature you attribute. And I have collected an opinion, very, very illustrative, opinion of the judge, Stevens. Judge Stevens stated that as long as an objective situation is established by the evidence, it not be shown that the situation will probably result in persecution, but it is enough that persecution is a reasonable possibility. So it is the test of, reasonable possibility of persecution that should be the bone of contention. And that should be supplemented with the, most credible, plausible, and unimpeachable or impeachable, what we call, contentions and justifications. In United Kingdom, House of Lords approved this particular, approach of the US Supreme Court. And House of Lords, in the case of R versus Secretary of State for the Home Department, it was a, ex parte decision on the part of the, House of Lords in 1988. Ex parte in the case of, Siva Kumaran. In this particular case, my dear friends, 6 applicants for asylum were Sri Lankan nationals who belong to the Tamil ethnic group. Secretary of State in United Kingdom refused to grant the applications on the ground that the facts known to him, the applicants had no reason for the fear if they returned to Sri Lanka. Their application therefore was rejected. Because this particular test that was, followed, American test, a test of reasonable possibility, when their applications were evaluated on the basis of this particular, test, then they could not contend what they wanted to contend. Justify. In another jurisdiction, that is Canada, the Federal Court of Appeal in Canada considered the approaches taken by the United States, Supreme Court. And they designed on the basis of this, test of reasonable possibility. The Canadian judicial system came out with a, an improved, what we call, version of this kind of a, test. What has been, coined by the US Supreme Court. The Canadian Federal Court applied a reasonable chance for fearing persecution as a test for determining the existence of a well-founded fear of persecution in a very, very celebrated case, and that is Adeji versus Minister of Employment and Immigration. This was a decision of 1989. And there is another important, decision R versus governor of Pantable prison. In this decision, the court was engaged in the construction of Section 4, subclause C of the Fugitive Offenders Act of 1967. In this particular section, it has been stated that a person shall not be returned under the act if it appears that he might, if returned, be prejudiced at his trial or punished, detained or restricted in his personal liberty by reasons of his race. Entire what you call grounds which have been adumbrated and in the definition as per 1951 convention relating to the status of refugees were cited. Therefore, in this decision, that is R versus governor of Pantable, the court made reference to reasonable chance, substantial what we call grounds, or serious possibility of the likelihood of the detention or restrictions of the fugitive upon his return to his country of origin. So cumulatively speaking, if we identify what kind of tests have been identified by various jurisdictions, English jurisdictions, American jurisdiction or Canadian judicial system, then we have identified three important tests, or we may also address them as three important grounds to determine the refugee status. And these grounds or these tests, three important tests: the test of reasonable possibility, number one; the test of reasonable likelihood, that is number two; the third test, that is the test of reasonable chance. And my dear friends, all these or other tests have been variously used to determine objectively a well-founded fear of persecution. Now, it becomes very, very relevant at this very stage, and we cannot deny this particular fact. After these adumbrations, deliberations with multiple dimensions, the question that still remains to be unanswered, and that should also be attended head on, and that is a question, a very simple question. Prima facie it appears it is a very simple question, but if you go further and try to dig its intersectionality, its hierarchical order, its intra-understanding fragmentation, then it becomes a very, very difficult question. And the question is, what is persecution? It appears very simple. But what is persecution? Or in the same way, if I put it like this, how should we try to define persecution? Is there any kind of a possibility to have a universally accepted definition of the term persecution? So what is your take? How do you perceive this idea of persecution? As a global citizen, as a part of citizen journalism, as a part of well-informed individual in the global society, as a part of civil society stakeholder, how do you perceive this idea of persecution? Is there any possibility to contemplate and determine the province of persecution? What exactly was the situation that compelled the framers of 1951 convention not to define the idea of persecution? What are the benefits of not to have a definition of persecution? What are the benefits to have a definition of persecution? What are the disadvantages of not having a definition of persecution? What are the disadvantages to have a definition of persecution? To what extent the word persecution is fit? It is going to be encapsulated, incorporated, and programmed in the artificial intelligence, and to what extent the artificial intelligence is able to incorporate the idea and appreciate the idea of persecution. Because when we are talking of persecution, artificial intelligence, then I have an apprehension of of colonization. Colonization in the sense that there has been some possibility, there have been an unwritten thinking that in the name of globalization, the occidental jurisdictions are primarily misappropriating and exploiting the resources, natural resources, as well as anthropological resources of the global south nation states. And in the same way, they have programmed their automated decision making mechanism, which is popularly known as algorithmic creations. If there happens to be, because it is very much possible that despite all kinds of deliberations, despite the creation and inventions of all kinds of what we call of subjective tests, objective tests, designed by the best judicial systems at international level, there is still a possibility that the people may not get justice, particularly those people who are hailing from the global south nation states and seeking refuge, sanctuaries, safeties, integration, and other important what we call livelihood driven necessities in the global north nation states. So in such a situation, how should we perceive the idea of persecution? Because if there happens to be a concept of what we call of artificial intelligence, then we should also contemplate how to decolonize artificial intelligence, how to neutralize artificial intelligence. Because as of now, a lot of discrimination has been reported, and that has been reported that due to the programming of the softwares, because of the applications of the softwares in the determination of refugee status, in the determination of granting of or the scientific and technological interventions at the borders level or on national borders, they have created a lot of discriminations, and people feel persecuted. So in this scenario, how should we visit the idea of persecution, and how should we what we call understand this entire understanding of of persecution? So what is your take? Anybody?
So,
Yeah, please.
the first sense when we think about persecution, it feels like like threat to life. But if we see the refugee crisis of today, I think persecution goes way beyond that. For example, the North Korean refugee, when they fled to South Korea via river or any other way, then they have the fear that if they go back to North Korea, then they will be sent to labor camps, and will be under the military detention. So that is also a fear of life and fear of persecution. So that also should be included. We have discussed numerously about climate refugee, that if they go back to their like original place, then the floods and other things might like hamper day to day life and may threaten their life, then that may also be included into the persecution. I think UNHCR, even the world community, should open up to the view of persecution in a new way.
Yeah. Very relevant intervention. Thank you very much for your contribution. Yes, Mohammad Imran Sahab, you were also scheduled to say something.
But am I audible?
Pardon? Yeah,
Am
you
I
are
audible?
audible. Yeah, please go ahead.
Okay. So I think, sir, we have two issues here. One, to define the word persecution, and then how the AI system works for the determination of refugee status, considering the idea of persecution. So, sir, I think I have not read your article on the issue, but still, what I get that AI quantifies everything, right? The artificial intelligence runs in binary numbers, right? So I still have no idea how the computer quantifies the threat. For example, there is a scholar, his name is Lord Hoffman. He says that persecution is equal to serious harm plus failure of state protection.
Hmm.
So I don't know if we have that much of advanced AI which can actually quantify that the state has failed to protect or there is a serious harm. For example, he also gives example that state has failed to protect a shopkeeper in Germany who was a Jew. So how AI will be the AI will be able to quantify that particular situation. For example, there is state in which let's say it's a big country, and in particular state some people of the minority community are being killed or state is not protecting it, they are being killed, and some people in other part of that country fear persecution and they leave the country and they enter into the neighboring country. So whether
Hmm.
AI will be able to quantify that particular idea. So I have the only problem is the how AI works for this particular situation.
Right. Yeah. Thank you very much for your taking me to some of the important dimensions of artificial intelligence application. Any other observation, my dear friends? Well, I would like to listen something from Miss Malla, if she is
Yeah,
amenable to my request.
yeah. Am I audible, sir?
Yeah, you are audible. Yeah, please.
So, what I feel like the term persecution has not been defined in Refugee Convention, and I think this is good in the present context in the sense that it has given a sufficient leeway to cope with the changing scenario, because the ground for persecution may not be same throughout all period of a time. If we see prior 1950, there were no concept of the climate refugees, but now we have a concept of the climate refugee. And because the persecution has not been confined within the watertight compartment under the Refugee Convention, we can also take a advantage of putting the new form of refugee under those definitions. So I think this is a good aspect. But at the same time, sir, what I believe is nothing should be too subjective, because when you keep everything subjective, then it may also defeat the justice. So, like, what I feel is that there has been a two word that is used in the convention as a definition, that is well founded and persecution. Well founded, whereas is a objective in the sense, and persecution is subjective. So I think these two should be used as a complementary to limit each other from being
Yeah.
unlimited, and that is
Yeah.
how I think this one has to define the term persecution. It is
Yeah.
subjective, but subjective does not mean that it is beyond the limitation. So
Yeah.
it should be defined under the limitation by the use of the term well founded. That is what I feel. And as far as AI is concerned, I don't have much idea, so I would not like to comment on that, sir, because I haven't
No, no.
studied it.
Very soon, you are going to have your own opinion, independent opinion on AI also. We would be, deliberating at length because it has of late become very, very important, and majority of the nation states, and particularly Though AI has given a new limelight. Otherwise, the entire journey has started for the first time. It has been, noticed in 1956 at the Dartmouth, conference. Uh, that was, for the first time, not for the first time, but in a very formalized manner for the first time. A paper was, presented in that particular, international conference by John McCarthy, who is considered subsequently and nomenclatured as the father of artificial intelligence. But there have been certain important instances even prior to that particular conference. So we would also be discussing the genesis, everything, the history, the entire journey of artificial intelligence, and particularly to what extent it has been influencing and incorporated in the area of international criminal law, in the area of international human rights law, in the area of international refugee law, though it has always been there in the field of what we call of forensic sciences and other important, and a new right is also what we call emerging, and that is today known as a right to science. So right to science, I would also be deliberating that particular aspect of that too on the constitutional footing as well as on international human rights law foundations. So we would be attending. So I have received three important, observations, and I will definitely be, responding to these, three important observations of Mr. Miss, Anupaji, then Mr. Mohammed Imran, and then Ms. Prakriti Malla. So it's a very valuable, intervention on their part. So I would be attending these observations in the next engagement, and I will begin. First, I would deliberate these three important observations, and thereafter, I will, start my deliberations, persecution, as well as artificial intelligence. Meanwhile, today in the night, I would definitely be sharing whatever we have deliberated so far. So thank you very much, my dear friends, for listening and giving me your valuable time. So thank you very much. Thank you, sir. You're welcome.
Thank you, sir.
Thank you. Thank you.
Sir,